Hello everyone, and thank you so much for joining us for our presentation today on the L-1 visa. My name is Dustin Salariaga, and I am a senior associate at Scott Legal PC. As I mentioned, today we're going to be talking about the L-1 visa, which is a very common option for those who work abroad and are being sent to the United States to work for a location of the employer that is in the United States. We'll be talking about both the L1A option and the L1B visa option. Before we get started, a few things to cover. First is that although our firm does focus on business immigration, we are a full service immigration firm. So we do handle family immigration, humanitarian immigration, and really everything involving US immigration. So if you have questions or concerns involving really any aspect of immigration, even if it's not business immigration, we do hope you'll reach out to us. This webinar is part of a series. We try to do at least 2 webinars a month, and usually we do many more than that. And we do these on the full spectrum of immigration topics. So after this presentation, you'll be receiving an email with a link where you can sign up for our future webinars. So we do hope to see you on those moving forward. We also, in that email, will be sending you a copy of the PowerPoint that you see on your screen. And we'll also send you a link to our YouTube channel. We try to put very high quality information on our YouTube channel through both shorter videos as well as full-length webinars. And on that note, this webinar is being recorded and it will be posted to our YouTube channel afterwards. So we do hope that you check out our channel. If you have a question, please do send it in through either the chat function or the Q&A box on Zoom. I will be monitoring those, and I'll either save the question for the end of the presentation or I'll answer it when it's asked if it's relevant to what we're talking about. Okay, without further ado, let's go ahead and dive in and talk about the L1 visa requirements. So the L1 visa allows companies based outside the United States to transfer certain employees to a US company that they have a relationship with. The basic requirements of the visa is that there must be a qualifying relationship between the foreign office and the office in the United States. So the foreign company and the US company must have a qualifying relationship as either a parent, an affiliate, a branch, or a subsidiary of one another. And each of those terms is defined differently. It can be the foreign company having a certain amount of control over the US company. It can be that the foreign company owns the US company or has the same owners as the US company. So there are a number of ways to satisfy the qualifying relationship requirement, but just know that this is one of the threshold requirements. There must be this qualifying relationship between the US company and the foreign company. Both of the companies, the US company and the foreign company, must be doing business on an ongoing basis. Now, doing business means the regular, systematic, and continuous provision of goods and/or services by the organization. It does not include the mere presence of an agent or an office of the qualifying organization in the United States and abroad. So in other words, doing business is not just setting up an LLC in the United States. It really is that the US entity and the foreign entity really need to actually be engaging in the act of business. Now, if the US company is a startup, if it has not been doing business for a year, then the L visa can be used, but it would be used as what's called a new office L visa. We'll talk about that on the next slide, and there are some additional requirements that come with an L visa petition for a new office, to set up a new office in the United States. The third requirement that you see on your screen is that the employee, in other words, the person who would receive the L1A or the L1B visa, must have worked for the foreign company for at least 1 year, one continuous year in the past 3 years. And they must have done so in a managerial, executive, or a specialized knowledge position. So if the person was hired only recently, within a year, then they would not meet this requirement. On the other hand, if they worked for the company for a full year, but it was 3 years ago, that would satisfy the requirement. So it has to be one continuous year within the last 3 years. The L1A requires that the employee applicant's US role will be managerial. Now, what managerial is defined as is the ability to supervise and control the work of professional employees and to manage the organization or a department, subdivision, function, component, or an essential function of it. So that is the managerial capacity. Executive capacity is the ability to make decisions of wide latitude without much oversight. So you really have discretion to guide a significant part of the business without much oversight. And we will talk more about that in a few minutes. The L1B visa, in contrast, is for employees who have specialized knowledge. So the L1A is for managers and executives. The L1B is for employees with specialized knowledge. Now, what does that mean? That means that they either have special or advanced knowledge of how the organization manufactures, produces, or develops its products or services. And we will talk more about that as well. Now, the L1A for managers or executives can be renewed for up to 7 years, The L1B for employees with specialized knowledge can be renewed for up to 5 years. So there is that time limit on those. Let's talk a bit about new office requirements. As I mentioned before, there is an exception to the US company doing business in the US for at least a year. Typically, the US business must do business in the US for at least a year before the L1 visa application is filed. There's an exception, and if you're seeking that exception, you have to apply for an L1 new office visa. And as I mentioned before, there are some additional requirements here. For the L1A, again for managers or executives, the application, the petition for the L1A new office visa must show that the company has secured sufficient physical premises to house the new office. So that means you actually need an office space. And not only do you need an office space, it's ideal if you can show that the office space is sufficient in size that it actually will house the business as it grows in the first year. Second, the employee must have been an executive or manager for 1 continuous year out of the past 3 years, preceding the petition. And the proposed employment in the US, what they'll be doing in the US, must involve managerial or executive authority over the new operation. And again, just to go over that again, that means the ability to supervise and control the work of professional employees and to manage the organization or a significant part of it without much oversight. The application must also show that the US operation, the startup that's been operational for less than a year, will support an executive or managerial position within 1 year of approval of the petition. So how do you show that? You would show that by showing the scope of the office, the organizational structure and its financial goals. You may include a business plan to show where the US company plans to be within its first year and that it will support that executive or managerial position within that time. You will need to show the size of the investment in the US company and the financial ability of the foreign company to pay the employee who's coming to this startup in the US to start it. And you'd also include evidence showing the organizational structure of the foreign company. So really kind of supporting the fact that the foreign company is in a position to kind of support the creation of this US startup. Or new office, as the regulations call it. The L1B new office petition, in contrast, again, the L1B is for an employee with specialized knowledge. That petition must show that the company has secured sufficient physical premises, again, same as the L1A, And it must show that the petitioner, meaning the company that is sending the employee to the US, has the financial ability to pay the employee and to actually pay to start the business in the United States. I've talked about this already. I've referenced it, but let's talk a little bit about the definition of executives and managers, starting with executive capacity. What does that mean when the regulations require that the L-1A employee must be coming to the US to work either in a managerial or an executive capacity? Executive capacity, in summary, is the ability to make decisions of a wide latitude, meaning they broadly affect the company, without much oversight. So they would direct the management of the organization as a whole, or it could be a component of the business or a function of it, a significant component or function of the business. They may establish the goals and policies of the organization or a component of or function of it. They would exercise, again, wide latitude, and they would have broad discretion in their decision-making authority. So when you think of a role like the chief operations officer, the chief executive officer, the chief financial officer, the chief marketing officer, these are all examples of roles where these positions, they have minimal authority above them to control their decision making. They have broad authority, and their decisions really do impact the direction of the business. That's what the government has in mind when it's talking about executive capacity. And finally, under executive capacity, you see on your screens that the applicant receives only general supervision or direction. Now, that could be from higher executives, it could be the board of directors or shareholders of the organization. What about managerial capacity? And again, both of these definitions are under the L-1A visa category as opposed to the L-1B. So managerial capacity generally refers to the ability of the employee to supervise and control the work of professional employees and to manage the company or a department, subdivision, or function of it, okay? So that means that the applicant manages, supervises, and controls the work of others, right? And typically this could be people of a significant number or who themselves, perform an important task. Or it could be supervising and managing an essential function within the organization. So there is some opportunity here. If the manager isn't necessarily overseeing a significant number of people, it is possible to make the argument that their oversight is over a function or a component or a subdivision of the organization or the company. Now, this person would also typically have the authority to hire and fire, or recommend those actions and to take other personnel actions such as promotions, etc. So let's move to the final bullet. This person must also exercise discretion over the day-to-day operations of the activity or function for which they have authority. So a first-line supervisor, for example, is not considered to be acting in a managerial capacity just because they have supervisory duties. You really are looking for significant discretion over the day-to-day operations of the activity or function that you're applying under. So let's talk a little bit about the L-1B specialized knowledge option. Specialized knowledge, in summary, means having either special or advanced knowledge of how the organization manufactures, produces, or develops its products or services. Okay, so if we get into the more detailed definition that you see on your screen, it is specialized knowledge that is possessed by an individual of the organization about the organization's product, service, research, equipment, techniques, management, or other interests, and its application in international markets, or an advanced level of knowledge or expertise in the organization's processes and procedures. Okay, so it's also important to keep in mind if you're trying to figure out if an employee does have this specialized or advanced knowledge, is this knowledge that's commonly known by employees of the company? If the answer is yes, then it's likely that the person would not qualify. You're really looking for knowledge that not everyone at the company has, that this employee really is unique in having, and therefore this individual is the one who needs to go to the US to work for the US office or the US company. Now, when the government is actually determining whether an applicant has specialized knowledge, it's helpful to look at the U.S. Citizenship and Immigration Services Policy Manual. So this is a manual published by the government, and it does apply to USCIS. It is guidance for the people who, the officials who will be reviewing these applications. So it's helpful to look at that. And when we look at that policy manual, we see that the government considers and will review the applicant's knowledge of how the organization, what I already shared before, how the organization manufactures, produces, or develops its products, services, etc., the products and services of the company. Now, the government will review the beneficiary's knowledge of the specific petitioning organization's processes and procedures when determining whether they have advanced knowledge. So we'll talk a little bit later about requests for evidence, but one thing we do see is that the government will oftentimes follow up on these applications asking for additional information and documentation, proving that the visa applicant actually does have special or advanced knowledge. So you do want to think about how to show in the application that this really is a person who has unique knowledge of the company. And that can be shown by their relative position on an organizational chart, by the projects they've worked on in the past, by the people who answer to them and who they then answer to, and et cetera. And we'll talk a little bit more about that in a later slide. So what documents need to be submitted with an L-1 visa application? An L-1 application starts with an application to U.S. Citizenship and Immigration Services, or USCIS, and that is on the Form I-129. You would also include with the I-129 corporate documents that show the qualifying relationship between the foreign company and the U.S. company. That can include, again, if we go back to the definition, the relationship needs to be a subsidiary, a parent, a affiliate, along these lines. So what you really want to show in that documentation is either the amount of control that the foreign company has over the US company, or vice versa, or the ownership structure. So either that the two companies are owned by the same or same people or same parent, or something along those lines. You really want to tend to look at either control or ownership to prove that qualifying relationship. And proof that each company is doing business. Again, this means the active activity of business. This is not just having an LLC or a corporation in the US that has been dormant. The company actually needs to be engaging in business unless you're applying for the new office visa option. You'd prove that the company is doing business by including company tax returns, audited financial records, lease agreements showing that they have office space, client invoices showing that they're actually selling, payroll summaries showing that they're actually employing people, things along those lines. You'll also want to include in the application proof that the employee worked for the company abroad for one continuous year out of the past 3 years in a managerial, executive, or specialized knowledge role. So how would you do that? You may include a letter from the Human Resources Office that is signed by the human HR official saying that this person has been employed by a date certain. You would include pay records proving that the person has been paid by the company. You'd include their job description explaining what job duties they have and that they're managerial, executive, or specialized knowledge. You'd include an organizational chart showing the hierarchy of the company and that where this person falls in that hierarchy. And you'd provide evidence of the work product. What is the employee actually producing for the company that shows that their role is managerial, executive, or specialized knowledge? So that's the foreign employment. The other piece is proof that the employee's role in the United States will qualify as managerial, executive, or specialized knowledge. How do you do that? You would, similar to what I said before, provide a job description of what the person will be doing in the United States, provide an organizational chart of the US company and where the employee will fall in the US and in the company. You can also include internal company documents or memoranda explaining the transfer. So this could also be a letter from a high-ranking person at the company that explains what the employee will be doing in the United States. Now, as I mentioned before, the government has been issuing requests for evidence more frequently on L1 visa petitions. Recent statistics suggest that over 50%, over half of L1 petitions receive RFEs. An RFE is essentially when the government responds to an application by saying we need more documentation or information in order to reach a decision. And they're typically very specific about what additional information or documents they need. Now, most of the RFEs are challenging whether the applicant meets the definition of manager, executive, or specialized knowledge worker. So to respond to that, you really do want to include, ideally in the initial application, but if you receive an RFE in response to the RFE, detailed letters and organizational charts that provide details of what the employee has done abroad for the company over the last year of employment abroad, as well as what they will be doing at the US company. These letters and charts should be supplemented with objective evidence that support the statements that are made in the letters and charts. So you really want to provide documentation supporting your statements in the initial application or in response to the RFE that shows that the person's work product, their emails, the company's policy handbooks, the employee's performance reviews, etc., really do clearly show that they have been working in a managerial, executive, or specialized knowledge role, and that they will be doing that in the United States. So let's talk a little bit about timing and dependence. So as I mentioned before, L1 petitions are first submitted to USCIS. There is not an option to first go to the consulate and apply there. So you do that by filing the I-129, as I mentioned before. These petitions do have a premium processing option. What that is if you pay an additional $2,500 to USCIS, USCIS will provide a decision within 15 calendar days. So that is a wonderful option if you need an expedited response from USCIS. I say response because the response could be an approval, a denial, or as I mentioned before, a request for evidence. If you do get a request for evidence and you have chosen premium processing, then the government will decide your application within 15 calendar days of receiving your response to the RFE. So that is a benefit there as well. If you don't opt for the premium processing option, the I-129 is taking several months. So it's either going to be that 15 calendar day time frame if you choose to pay that $2,500 fee for premium processing, or it's going to be several months if you choose not to. Now, after the L1 petition, the I-129 is approved by USCIS. The employee would then schedule an appointment at the US consulate where they would go, they would have their interview, and they would receive the L1 visa stamp in their passport. And at that point, they can enter the US in L1 status. If the employee is already in the US, let's say that they're here maybe as a student, for example, and they worked for the company in the past over the last 3 years at some point for a year, then they do have the option to apply to change their status to L1 status. And they would do that by filing the I-129 through USCIS and requesting a change of status. They do not need to include the consular piece. Now, if they do that, then they would get a new I-94, which would give them L1 status. However, the moment that they travel, they would need a visa to come back into the US in L1 status. So that is a benefit of getting an L-1 visa. Now, spouses and unmarried children under 21 can accompany the employee, the principal L-1 visa holder. The children and the spouse would receive an L-2 dependent visa. Children and the spouse can enroll in school while in L-2 dependent status. And fortunately, the spouse gets immediate work authorization upon receiving L-2 dependent status. So that is a recent change over the last 2 years where they do not need to apply for a separate work permit. They actually can work based on their I-94 alone, which is a huge benefit for many people. A very common question we receive is, does the L-1 visa lead to a green card? Excuse me. And the answer is that in the United States, U.S. immigration law doesn't really work in terms of a non-immigrant visa like an L-1 leading to a green card. It's not a point system. To get a green card in the United States, you need to independently qualify for the green card, whether that is based on a family relationship you have, or if it's based on an employer petitioning for a green card on your behalf. What we oftentimes see is that people who are on an L-1A, manager or executive visa, find that the EB-1C green card is a good option. EB means employment-based. So whenever you see a green card that starts with EB, whether EB1, EB2, EB3, EB4, EB5, those are all employment-based green cards versus family-based green cards. So the EB-1C is a green card for a multinational manager or an executive. The requirements are similar to the L-1A, but they are heightened, so they are harder to meet. There does need to be a qualifying relationship between the company abroad and the US company. Both companies, as with the L-1, must be doing business, and the prospective US employer must have been doing business for at least 1 year. That would be the employer that's sponsoring the green card. The employee must have worked in an executive or managerial role for at least 1 continuous year in the past 3 years, and the date will be adjusted if the employee has been working for the petitioner in the US. In other words, if the initial application showed that the employee had been working for a year within the last 3, which again is one of the requirements for the L-1, but then the person comes to the US and works for the US company for 5 years, which is permitted on the L-1, well, then they would cease to satisfy that 1 year abroad requirement because it's been more than 3 years. The government will pause that timeline. So they would still qualify for the green card. The time working for the employer in the US wouldn't count against them. No labor certification is required. So for the EB-1C, that is a big benefit. Now, for L-1B applicants, again, specialized knowledge, they would typically pursue an employment-based green card by going through what's called the PERM process. And that is a quite extensive process that typically takes a couple years, where the US employer would actually advertise the job domestically in the US, see if there is a qualified US worker who's willing and able to fill it. If there is a US worker, then the PERM process would terminate and they would not be able to hire the L-1B applicant, the green card applicant. But if there is no US worker who's qualified and able and applies for the job, then the PERM process, then the green card application process would continue and the employer would file an I-140 for the worker and eventually file an I-485. The worker would file an I-485 for a green card, or would do consular processing by filing a DS-260. So L-1B is typically the PERM process where the employer is testing the market. EB-1C is for higher level executives, so testing the labor market is not necessary. Now we'll switch to any questions you all may have. I haven't received any so far, I do thank you all for taking the time to join me for this presentation. Please do reach out to our firm if we can be of any help. We do regularly schedule consultations, so reach out to us if we can be helpful. And in the meantime, please don't hesitate to visit our YouTube channel. and our blog on our website. Keep an eye out for that email that will follow up with links to that. So thank you again for your time. We look forward to seeing you on future webinars. Have a great day.